咁我哋開會啦。咁我歡迎政府部門呢。
It's time for us to start our meeting. Welcome to this meeting of the Bills Committee on Copyright Amendment Bill 2014. Item 1 on the agenda, confirmation of the minutes of the meeting held on the 8th of December 2014. The Secretariat has not received any proposal for amendment. Can we have the minutes confirmed? Thank you. Item 2, meeting with the administration. Our legal advisor has passed some questions to the administration, and the administration has submitted a reply to us. Mr. Chairman, we had some communication with your legal advisor in terms of technical and drafting issues. The first questions have been answered in the paper. I think the paper is self-explanatory. If there are questions, we are willing to answer them now. As for the remaining questions, they'll be handled in due course. All right, we'll proceed to clause by clause scrutiny. Last time we're on clause 18 in relation to repealing section 39 on criticism, review, quotation, and reporting and commenting on current events. If you want to have a look at the marked up copy, is page 17. Ms. Strong? We'll proceed to section 39 in relation to criticism, review, quotation, and reporting and commenting on current events. There are two aspects of updating in terms of quotation and citation on current events. So we've redrafted the section. So our lead members in this scrutiny, 39(1), fair dealing with the work for the purpose of criticism or review of the work or another work or of a performance of a work does not infringe any copyright in the work or in the case of a published edition in the typographical arrangement if A, the work has been released or communicated to the public, and B, subject to subsection 6, the dealing is accompanied by a sufficient acknowledgement. That means the work has to be known by the public, and secondly, if an affirmation statement is made, it will be all right. Bracket 2, copyright in a work is not infringed by the use of a quotation from the work, whether for the purpose of criticism, review, or otherwise, if the following conditions are satisfied. The first condition is the same as that in bracket 1. That is, the work has been released or communicated to the public. Bracket B, the use of the quotation is fair dealing with the work. And then condition C, the extent of the quotation is no more than is required by the specific purpose for which it is used. And the final condition is when reasonable, the use of the quotation is accompanied by a sufficient acknowledgement. Bracket 3, fair dealing with the work for the purpose of reporting or commenting on current events does not infringe any copyright in the work or in the case of a published edition in the typographical arrangement if the dealing is accompanied by a sufficient acknowledgement, subject to subsection 6. The final subsection proposed in determining whether any dealing with the work is fair dealing under subsection 1, 2b, or 3 in relation to criticism, review, quotation, and reporting, and commenting on current events, the court have to take into account a number of circumstances of the case. A, the purpose and nature of the dealing, including whether the dealing is for a non-profit making purpose and whether the dealing is of a commercial nature. B, the nature of the work. C, the amount and substantiality of the portion dealt with in relation to the work as a whole, and the final one, the effect of the dealing on the potential market for or value of the work. Subsection 5 stipulates that for the purposes of subsections 1A and 2A, this is to define what's meant by publication. That is, a work has been released to the public if it has been provided to the public by any means other than by communication to the public. So this is to explain what's meant by provided to the public. So, if the following means are used for the provision of the work to the public, then this stipulation will apply. First, the issue of copies of the work to the public. 2, the rental of copies of the work to the public. And 3, the performance, exhibition, playing or showing of the work to the public. Now, all these means of provision to the public is applicable to 39.123 and the exemption therein. Subsection 6 explains under what circumstances there is a sufficient acknowledgement. It is not necessary to accompany the relevant dealing with a sufficient acknowledgement if it is not reasonably practicable to do so. Any questions, members? Mr. Gary Fan? Thank you, Chairman. I have 2 questions. Well, on ruling whether or not there's a fair dealing of commenting on current events, the court will have to consider the potential market value. What if the work is already commenting on current events like songs, dramas, and secondary creation is a citation of the work, the original work in commenting current events? Will there be a potential market for or value of the work? Is there any chance for this secondary creation to be exempted? I believe in commenting, this second work will have a different stance from the first one. So even though there's the same objective, the target and market will be different. So the exemption will still apply. All right. What about 39.4c? Some conditions are set out there. Are these conditions vague? Because nothing is mentioned about the portion cited or used or quoted. Take, for example, part of a newscast is quoted. Will it be considered as quotation, or a few portions of a newscast are edited to form a new episode? Say, each portion lasts only a few seconds. For 2C, in relation to quotation, copyright in a work is not infringed by the use of a quotation from the work if the extent of the quotation is no more than is required by the specific purpose for which it is used. no percentage is stipulated here. So long as C is satisfied. Well, some dialogues may be taken out from a full episode and then combined together to form another piece of work. Well, it depends on whether it is excessive quotation. Maybe you're combining different images and different dialogues to bring out your viewpoint. Then you can cite this provision for the purpose of exemption. Mr. Ma Fong Kwok, I'd like to ask about 39(2). Whether for the purpose of criticism, review, or otherwise is used here. What do you mean by or otherwise? Because this section is mainly for the provision of exemption for criticism, review, quotation, and reporting and commenting. So what do you mean by or otherwise is rather broad.
It can be understood as excluding criticism. And when the words or otherwise is used, what is it actually referring to? Because for the others, they have been specified criticism, commenting, and reporting. So why do you have to add the word or otherwise? Because once it's written and it's not clearly defined, then one interpretation is that it can be rather wide, a scope. And 39(3). The administration proposes exemption for commenting on current events. In the recent UK review, commenting on current events was not exempted. In Section 30 of the UK law is criticism, review, quotation, and news reporting. So there is no commenting on current events. So I would like to ask the administration, why do we exempt commenting on current events? Are there any other overseas jurisdictions that has given a similar exemption? Why do we not follow the UK practice? Ms. Chong. First, in relation to Section 39(2), that is, for the purpose of criticism, review, or otherwise. What is referred to by otherwise? And it already says criticism and review, that is in subsection 1 and in subsection 2, and it refers to other purposes other than criticism or review. For example, discussion. Say, for example, copyrighted work is used in a discussion and it's not criticism and it's simply quoted to elaborate an argument or for the provision of information. So it's not for the purpose of criticism, commenting or reporting on current event. It's simply a topic for discussion socially. So apart from purposes of criticism and commenting or reporting, it can still be used for other purposes. This drafting style is the same as the exemption approach adopted by the UK. So it's criticism, review, or otherwise. Say, for example, for provision of information, academic discussion. So there is a certain scope allowing users to use copyrighted works, and it's not limited to those stated in subsection 1. Well, you said that is also included in the UK. Then how come the administration did not make it clear that is for academic discussion, debate, etc.? Just give an exhaustive list of all the purposes instead of using or otherwise, which is rather general. If you say that it follows the UK example, then I have a question. Why does the other one not follow the UK exemption, that is Why does the UK not give exemption on commenting on current events? It's explained in the legislative brief why quotation is proposed as a new exemption. When it comes to quotation, well, it's the Berne Convention. The Berne Convention. There is no specific definition, and this will provide sufficient flexibility to ensure fair use of copyrighted works. We've also taken reference of the latest legislation of the UK. Second point. Next to commenting on current events will be an advantage. Addition of exemption should be supported by sound public administration reasons. And commenting on current event or reporting on current event is already an exemption. From the views we've received, well, one of them is from the Bar Association, and it says that commenting on current event is similar to reporting on current event, and the public policy purpose is to promote freedom of press. This will be conducive to public freedom. That's why we have adopted this approach by adding exemption on commenting on current events. Mr. Sin Chung Kai, a similar question. 39 subsection 2C. The quotation is by specific purpose. I think without a specific purpose is a rather common occurrence. How do you deal with that? Is it allowed? Because if you ask, a lot of people will say, I want to. Maybe you want to or you like to itself is a specific purpose. Let's come back to the fundamentals. One of the basic principles is that when it comes to copyrighted works, we have to respect the intellectual property rights. And without the consent of the owner, you may still allow to use that. Well, if you're using someone else's property, it should be supported by sound public policy reasons. So out of the many provisions in different circumstances, we provide for exemptions for users to use copyrighted works without the consent of owners. And that is the reason adopted when we add exemptions, whether it is pastiche, parody, or commenting on current events, is supported by sound public administration policy. Say, for example, on a social occasion, you want to use a piece of copyrighted work to express your feelings, or in an academic discussion, you use copyrighted work to support your argument. It's a sound reason. Maybe that person cannot voice the specific purpose, but it is still a specific purpose. So, in the court, the defendant is asked for what purpose, and the answer is for people to know it. Now, then the reason itself is a good reason, right? A good purpose. Of course, it will have to be at appropriate extent and meet the requirements of a fair dealing. It should be supported by sound argument. I know you're not a judge and you're not here to explain the law, but you should know about it because you're part of the drafting. For 39(2)(c), if someone says the purpose is for more people to know about this, then it can be reasonable purpose. Say, for example, if the person wants to introduce a piece of work, to praise it, to let more people know about it, then is something included in our exemption. Okay, to complement it is positive, and to criticize is a negative, and to comment, to let people know, is neutral. Well, we have to make sure that it is to a reasonable extent. Can you elaborate on that? What is a reasonable extent? Say, for example, it's academic work when such is quoted to support your argument, then is for a certain purpose. And under the current copyright ordinance, well, commenting and criticism is limited to the piece of work itself, and that is rather narrow. And so, if someone else's work is quoted to support his own argument, then some of it is quoted, then is the extent is stated in the law, because there will be something for the court to rely on. Mr. Ray Chan. So about acknowledgement, 39(1)(b), that the dealing has been sufficiently acknowledged. So as far as practicable, the acknowledgement will have to be made, right? Say, for example, I want to quote a newspaper clipping, and we know which newspaper it is. Should I still add an acknowledgement? And sufficient. What is meant by sufficient? Just the name of the newspaper, or the date, or supplementary information as far as I can do. And this is not reasonably practicable. So is it the case that if it's not reasonably practicable, I don't have to make an acknowledgement? Ms. Chong, let me explain to you what is sufficient acknowledgement. Under Section 198 of the Copyright Ordinance, is a sufficient acknowledgement for if you let people know that is the title of the piece of work and the author. If you don't know the title, then it can be in the form of a description or an introduction. There is a statutory requirement of acknowledgement. So if you can describe the work, give the title if you know about it, so that people will know what work it is, and on top of that, the author. And for subsection 6, reasonably practicable, or what is not reasonably practicable. If it is an anonymous piece of work, or untitled, then there is no way for you to give an acknowledgement. And in this circumstance, then it is not reasonably practicable to give an acknowledgement. So even if you use this work without an acknowledgement, it is allowed. So what about the newspaper clipping? I post it. What do I have to do to satisfy the provision of a title of author? If it's a newspaper cutting, and if the newspaper did not specify that the name of the author, but you have cited the newspaper, the name of the newspaper, then to a certain extent you have given the information. There is no need to give a date, because it's not required by the law. Of course, you can say that it is extracted from this newspaper on this date. The intent is for people to know the source. If the limited information is already expressed in the clipping itself, it constitutes sufficient acknowledgement. Of course, unless you know the author. What about the screen capture of the newspaper? And there is sufficient information for people to identify the newspaper, then there is no need for me to add a caption or a line. Is that right?
So I have to proactively provide this sufficient acknowledgement. Well, I think a few meetings ago this was asked. Say if a certain newspaper or a certain TV station is already known for that clipping, such that the author and title of the original work are known, then it will suffice. The law won't require a repetition of those particulars. Mr. To, well, Section 39, as proposed, is rather complicated. So for 39 bracket 1, 2, 3, and 4, or rather 1, 2, and 4, and 5 as well, I have questions. First of all, about Section 39(1), there it is mentioned criticism or review of a performance. It may be a drama, a musical, with lyrics and the staff. Here, the expression is does not infringe any copyright in the work, or in the case of a published edition, in the typographical arrangement. Dramas, musicals, etc. covered? Because for these forms of work, they may also possess copyright in the typographical arrangement. Ms. Chong? Well, there's no restriction on the type of work. As for the performance you mentioned, if you look at the existing copyright ordinance, we do say what are meant by copyright works: literature, art, musical, sound, films, etc. So if you comment or criticize a work, you're not restricted to a particular work type. But of course, if a performance is involved, that's also included. As for the published edition, we're talking about reprographical right. So you should separate those two. If you comment on or criticize copyright-protected works, be they in sound form, printed form, or other forms, if you satisfy the conditions here, you're not infringing the copyright, including a published edition in the typographical arrangement. Mr. Chairman, I'd like to know what type of work involves a performance with a published edition in the typographical arrangement. It seems that the official's explanation is not too much different from what I said. That is, for staged performances, they may have a published edition. It's just like a drama on stage. There's also a script. And the script can also be sold. It's a published edition in the typographical arrangement. I just want to clarify whether my understanding is correct. When we criticize a drama, for example, if I quote certain dialogues therein, I won't be infringing the copyright of the work. I just want to clarify whether that understanding is correct. If the official considers me correct, then actually we're talking about the same thing. Well, I'd like to use the example of Miss Ode. Drama. Drama is a literary work protected by the copyright ordinance. For a literary work, if you comment on the literary work, you fall into this category. And if that drama is performed, if that literary work is performed on stage as a drama, say, if you comment on the stage performance, that's also included and exempted. And then if the script is in the typographical arrangement and owns a copyright, then it's also included here. Ms. Ito, all right, I understand that my understanding is correct. So apart from those work types that I mentioned, they can be performed on stage as stage productions. Can you think of other types of artistic work that can be included? For example, dance. How can you protect the copyright of a dance? I haven't seen any choreographical work, but I understand that they have graphics, etc. The choreography may not be published, but anyway, can you protect all performances staged? Take, for example, a dance. A certain portion of a dance is copied. Ms. Chong, well, all copyright works are covered. If you look at the existing ordinance, we have defined what are the protected copyright works. The copyright ordinance covers work, drama, musical, artistic, sound, film, broadcast, and published edition in the typographical arrangement. So this is covered. Well, what you mentioned is actually covered by literary work. If a dance is expressed by graphics, then the graphics are artistic work. If the dance is recorded, then sound work or recorded work are also covered. So we actually cover all works covered by the copyright ordinance, including dance and choreographic edition, as mentioned by you. Will please queue up again. Mr. Martha Kwok. Thank you, Chairman. I'd like to follow up on what the Deputy Secretary said. In spirit, I agree that comments on current events should be exempted. But when it comes to implementation, it's not that simple. Recently, there's a film that depicts a head of state being assassinated in the U.S. That caused controversy. Well, the news was broadcast throughout the world. Now, if that film is uploaded onto the internet with comments, say the film is cut up into 4 to 5 portions, and comments are made on each and every portion to the effect of whether or not the head of state has been anglicized, bad-mouthed, etc., etc. But if the whole film is not aired, there can't be comprehensive comments. So actually, the purpose is not for commenting on current events. It's just for broadcasting the film on the internet. At the moment, some films are uploaded onto the internet, well, sometimes as a form of retaliation only. Now, if somebody has done that, how will this new amendment deal with that scenario? I have another question. That's about the Berne Convention, which you mentioned. BIS 10 provides exemption, specific exemption for the media. There's also a general exemption. Before general exemption, there will be a 3-step test. As for the proposed amendment to 39(3) on the exemption for current events, I somehow feel that the target is a bit different from that of the Berne Convention. It seems that you have combined specific provision and general provision. Now, for exemption on comments on current events, is your proposal not in compliance with the Berne Convention? Thank you, Mr. Ma, for your comments. Thank you for your support of this ground for applying for exemption in the interest of the public. But of course, scenarios may vary. But under a fair treatment arrangement, we have to deal with comments on current affairs as well, current events as well. We have to consider all the factors related to the event. And the court will have a fair ruling. Here we have set out the major conditions for the reference of the court. For example, the purpose and nature of the dealing, in bracket 4, including whether the dealing is for profit-making or commercial nature, and then the amount and substantiality of the portion dealt with, the nature of the work, and the effect on the potential market. You have to weigh all these factors before you can say that the handling is fair, such that an exemption is justified. If it is actually an infringement act, there won't be this protection of fair and reasonable handling. For the Berne Convention, the most important factor is the three-step test. To allow each jurisdiction to offer exemption, such that the right of the copyright holder and the users can be balanced. The exemption we propose here does satisfy the criteria under the three-step test. Well, Ms. Claudia Mo has come back. Sorry? I'd like to clarify a point. Well, fair handling. Oh, of course, you try to be as fair as possible. But we are doing clause-by-clause scrutiny. I'm a bit worried because I learned from newspapers that there might be retaliation after the Occupy movement. In fact, most of the friends I know are not organizers of the movement. Just now, Mr. Ma Fong Kwok mentioned the scenario of comments on current events. That should be safe, according to you. But again, it said that if the state leaders are anglicized or bad-mouthed or smeared, then it may be different. I'd like to clarify one point. Well, if I comment on current events, I'll be exempted, right? You won't impose further vetting on me. That is, you won't examine whether or not I have anglicized, bad-mouthed, smeared, or teased, etc., of state leaders. Because I understand that teasing should be included because satire is covered in this bill. Now, if I comment on a current event, who has the final say in determining whether or not I am qualified for exemption? Who will answer this? Thank you, Ms. Mo, for your question. In the bill, a number of exemptions are provided. Precisely, this is to pinpoint certain acts in the use of copyright works which may cover satire, caricature, etc. That's why the scenario that you mentioned is definitely covered in the bill.
And you said that someone's done an act and thinks is entitled an exemption, but if the copyright owner thinks that no exemption should be given, of course, everyone has the right to take the case to the court. And in the end, it's for the court to decide whether exemption should be given. Ms. Mo? Well, I hope that when members speak, they should refrain from quoting from another member. I think for a screen or video capture, and they should be included. They are included under quotation. Is that right? And in image or video capture, how can you give sufficient acknowledgement? Does it mean that there should be an acknowledgement of each and every capture? Say, for example, there is a line by an actor talking about ATV, and so whenever ATV is mentioned, then that image captured will be used. Does it mean that when every single time is used, there should be an acknowledgement? We have proposed additional exemptions. Image capture may be protected under different categories. Say, for example, if it's commenting on current events, or is parody or criticism, they have their respective exemptions. And quotation is one of the exemptions that may be invoked to get an exemption, and there are different treatment. So when it comes to video or image capture, it can be exempted under quotation, meeting certain conditions. Yes. About the acknowledgement, is as far as practicable. No, I was talking about image or video capture. I think the principle is that when it's quoted, if you know the source of the original piece of work, say the author or the title. So if it's from a movie, then I need the name of the director and the title of the film. Yes. You should say that this is an extract from this movie, from this director, so that it is identifiable. If this is not done, then maybe exemption will not be given. So if it's reasonably practicable, you need to give an acknowledgement, because we have to respect the author or the director of the original piece of work. But if you don't even know that, then it may not apply. We're talking about reasonableness. In 39 bracket B, and what is not reasonably practicable, and you have used examples of anonymous work or untitled work. What if all of a sudden a piece of work that was originally anonymous is now claimed by someone? Then would someone hold me responsible? I know that in the UK, for anonymous piece of work, there is a statutory requirement for a person to go to the intellectual property department to make a statement that I can't find the author of the piece of work. For these anonymous piece of work, You talk about making a registration at the intellectual property department. Well, so far in Hong Kong, there is no such requirement, but you have to exercise due diligence. Well, but I don't even know whether it is an anonymous piece of work. Well, it's just for a reasonable man taken reasonable steps to find the author and fails to do so, then, well, it's not reasonably practicable then. Mr. Raymond Wong. We're now in section 39 bracket 2C. Required by the specific purpose for which it is used and the extent of the quotation. The extension of the quotation is no more than is required by the specific purpose for which it is used. We mentioned this in previous meetings. There are a lot of comments on current events, and they upload clips. And sometimes they have uploaded the entire clip, so that it meet this criteria, that is, extent is no more than is required. It should have been just a smaller section, and the person who uploaded it, you uploaded the entire clip. So it's not actually about the size, the length of the work. The extent of the quotation is no more than is required by the specific purpose for which it is used. Say, for example, I upload something and I had no time to edit it. Some of the works used is nicely edited, but for others it's not edited at all, for whatever purpose. Commenting, reporting. What does it mean by no more than required by the specific purpose? How do you know the purpose for uploading that piece of work? I think it's about the basics. The use of a copyrighted work without the consent of the owner. If a good reason is there to use a copyrighted work, I think it has to be fair. As I've previously said, that there should be a good reason to use a piece of copyrighted work without the consent of the copyright owner, whether it is for commenting or academic discussion. If it's only technically not feasible, no, but you failed to explain it. So who is to decide on this line, this sentence? What is meant by extent is no more than is required by the specific purpose for which it is used. What do you mean by no more than is required by the specific purpose? Let me give you some examples. We mentioned academic, thesis. But you try to limit it. It doesn't matter what example you give me, because you were not the one to decide in court. No more than is required by the specific purpose. So it can be anything. Laws should be specific. I don't doubt your motive, but this is the way it's drafted is problematic. When we add this new exemption, quotation, it's not limited to criticism or commenting. It's an exemption of a wider scope to facilitate users. But there are restrictions. We have to balance different interests by imposing restrictions. We've taken reference from the latest legislation passed in the UK. In the UK, the copyright ordinance was amended by adding new exemption. There has been a number of consultations after a review. It's been debated by the Parliament, and they arrived at the final version is of a very high reference value. I do think we have to mull over this. I don't find this acceptable. I may move a CSA if you insist. I don't want to waste time. There are other provisions that we have to scrutinize. In 13.9.5b, in determining whether a work has been released or communicated to the public, no account is to be taken of any unauthorized act. Determination, Chinese, 斷定. We would like to change the word to 裁定, decide or determining. Who is to answer? Legal advisor. In English, it's determining. We think 斷定, determining here is an acceptable version. There are various places when the same term is used in the copyright ordinance. If you use 裁定, decide, it's more commonly used in the context of a court or a tribunal, that is, in a judiciary. Here, it doesn't specify that is a determination of the court. So it's by a person based on facts. So the word 斷定, determining, is an appropriate term. So you now use 斷定, determine, not 裁定, decide. Yeah, we incline towards 斷定. Do you know what it actually means? It means that you decide and then you judge and then decide. When it comes to 裁定, it's more like a decision of the court. It is commonly used in Taiwan or on the mainland. And here we draft in English and is then translated. But if you use the term I propose, 裁定, then it has the connotation that is by the court. Legal advisor. Maybe the administration can explain what is the subject of this sentence? Who is to make that determination? The court or who else? Because it's missing here. There is no subject, whether it's court or which body, in determining. May I add, indeed, it's not limited to the judiciary or any specific body, because this provision applies to the general public in the use of copyrighted work. So even a general user can determine whether the work has been released or communicated to the public. Perhaps law draftsmen may decide. So it can be used anywhere by anyone, by members of the public, judiciary, the court, anybody. It applies to the person who needs to use this provision. Then the person will have to decide whether the work has been released or communicated. Of course, when it comes to the court, it will be done by the judiciary. But in general, when it comes to a provision is any reader? Well, so in, say for example, in subsection 4 is the court, so we use the term decide, 裁定, and here is for anyone. Then you use the term that applies to anyone. Then why don't you simply use the word any person? If you want to differentiate the two, one belongs to the decision of the court, the other one to anyone. Why do you have you get bogged down by this?
We understand your point, but at the end of the day, this is to determine something. Whether it's a judicial organ or an ordinary person, to determine on the basis of facts, etc., etc., it will be for somebody to decide whether or not a work is provided to the public. Well, if you insist not to change, then it's meaningless for me to continue to argue with you. Well, the draftsman can comment. Well, it doesn't matter. I can move a CSA during the second reading. Well, I can spend you half an hour on this, on the difference between 裁定 and 斷定. Well, we're not on politics. We're going through clause-by-clause scrutiny to find loopholes in the language, whether or not this exemption should be further discussed. How many more questions do you have? I have to allow other colleagues to speak as well. Who else has raised his or her hand? Ms. Ho. I'm in my first round only. Well, 39(3). Fair dealing with the work for the purpose of reporting or commenting on current events. Well, I won't spend time to read on. When I teach journalism. Now we're talking about a foreign language, Japanese. Japanese use Chinese characters. They're westernized rather early. So they've been using Chinese characters to explain or translate new foreign matters. Take, for example, economic, 經濟. In Chinese characters, 經濟 does not mean economics. So, since economics is a foreign term, we have to use the Chinese language to explain or translate new and modern concepts. Some concepts we originally had, but the Japanese use them as well. 文藝組織 are some examples. 報道 is the same. Because 道 means speak, or in English, report. But if you have the Chinese character 串 at the bottom, it will mean lead, leading, or guide. But for report, for news, you should use the Chinese character with the 串 at the bottom. Or rather, to use the word 道 in 道理. If you read the martial art dramas of Kim Yong, you find that he's been using the 道理 in 道, the 道 in 道理 instead of the 道 with a 串 at the bottom. So if you change this, good. If you're not willing to change it, I can spend 2 hours to explain the Chinese character 道. Well, in social media, people may neglect certain factors and fall into the legal net. Well, in bracket 6, it is not necessary to accompany the relevant dealing with a sufficient acknowledgement if it is not reasonably practicable to do so. Can you cite some examples? That is, examples for exemption from a sufficient acknowledgement. Examples, please, Ms. Chong. When I answered Mr. Chan's question, I said that the authors of certain works could not be traced. There are no titles as well. So, as you are not the author, you cannot casually and randomly give a title to the work. So, this is different from the situation when it is reasonably practicable to say trace the author or the title. Mr. To? Mr. Chairman, just now I asked about 39 bracket 1, but I have not finished yet. In 1A, the work has been released or communicated to the public. May I go back to 28A and 35? In 28A bracket 2, 3 conditions are covered. The communication of a work of any description to the public is an act restricted by the copyright in the work. That's one. And then in 2A, the broadcasting of the work. Sometimes public broadcasting is used. For broadcasting and cable transmission, it takes a big corporation to carry out the business. In 2012, that is at the end of the last term, when we went through the copyright ordinance, we're worried about the definition provided to the public, because in recent times, this is actually very dangerous. You easily fall into the scope. The making available of the work to the public is in condition C. So, if you press a button on your mobile phone and share some information with somebody else, you may fall into this category. So we're worried about criminalizing certain innocent acts. And now here in this amendment bill, you're providing some exemptions. For example, in 39 bracket 5, you mention a number of means of communication beyond provision to the public, that is broadcasting. But for 39.5, I do have a great doubt. In 5A, you say, provided to the public by any means, bracket, other than by communication to the public. And then you get Romans 1, 2, and 3. Communication is different from releasing. Well, just now I consulted Mr. Charles Mock by my side. I said in English the word release is rather common. So I'd like the officials to explain to us, how do you differentiate between release and communication? And then in Roman 3, you use showing to the public. So you have to tell us the differences among the different terms clearly. And then in Roman 3, you say the performance, exhibition, playing or showing of the work to the public. How is this related to other than by communication to the public? There's a duplication here. If you go back to 28A, including bracket 2, bracket A and bracket B. Both broadcasting and cable program servers are included. So there seems to be a conflict between 28A and 39.5. Mr. Wong, can you explain to us why this is not a duplication? Because in 28A, you expressly mentioned that broadcasting and cable program servers are covered. But then in 39.5, you obviously separate communication to the public from Roman 1, 2, and 3. But then in Roman 3, you have playing or showing of the work. So what are the differences? It's complicated because the draft itself is complicated. Oh, yes, I understand that the provisions themselves are complicated. I'll try my best to answer your questions. First of all, about communication to the public, it must be in electronic means. Communication by electronic means. You're correct. In 28A, cable program servers, cable communication are covered. That is, making available on the internet is also covered. So this is these are all included under the term communication. As regards 39 bracket 5, bracket A, in English is issue of the copy of the work to the public. You just mentioned release to the public. This release doesn't necessarily mean commercial release. It's just making public the work. So for Roman figures 1, 2, and 3 are not duplicating communication to the public, because communication to the public is only in electronic means. That is, broadcasting, cable programming, and through the internet. But for 39.5A1, it is the issues of copies of the work to the public. And number 2, the rental of copies of the work to the public. And 3, on-site performance, exhibition, playing or showing of a recorded work. And such playing or showing is not covered by communication to the public. So these 3 plus communication to the public will cover all forms of release or provision to the public. That's why we separate them. Mr. Chairman, under 5A, Roman figures 1 and 2, the issue of copies. Number 1 is easier to understand. Say if you produce a DVD or a USB which carry copies of the work. That's in electronic means. But what about Roman 3? Playing or showing of the work to the public, how can that be separated from what's in 28A, communication to the public? Be it a hard copy or an electronic copy, very often when we go to university to give a talk, we won't bring materials with ourselves. We use electronic forms and do a PowerPoint presentation. Again, for these performances, under 5A3, the use of electronic means is involved as well. So I can't see how you can separate 28A from 39.5A3. Mr. Chairman?
Thank Ms. Ho for the supplementary question. I think we're talking about two levels here. First, say a TV drama. Via electronic means is from the television station to the television set at your home. That is the communication. That is communication to the public. If I am a businessman, I put the television set out and play the TV drama. Now then is showing to the public. Then it's not under the scope of communication by electronic means. Say there is a link on YouTube, then the piece of work came from the server to my computer, then is communication by electronic means. And it's communication to the public by electronic means. And if I put the screen in the public and I show it to the public, then it is playing to the public. So on a certain occasion, you use a monitor or a screen to show to the public, then is called playing to the public. But there is an electronic media used. So for 35A, there is a bracket other than by communication to the public. Should be incorporated under 28 as well, that is by electronic means. And the playing or showing to the public may be a duplication. Well, I can't think of how you can amend it off the top of my head, but for 28A and 39.5A3 there is a conflict. So I now ask the question, and I ask the officials to draft it in a better way under 39.5A3, that is the performance, exhibition, playing or showing of the work to the public. To make it easily differentiable from 28A2, that is communication by electronic means to the public. You understand the concern of Ms. Ho, is that right? Do you first understand her concern? Perhaps I will defer to Ms. Chong. Well, when it comes to playing or showing to the public, and if you understand it along the lines of public performance, the recipients are actually on site. But if it's by electronic means, then is released by electronic means. That means the one who releases it is not in the same place as the recipient. Well, performing to the public, then the performer is at the same place as the public. Now, exhibition is the same. The piece of work is exhibited at the same time and same place as the recipient. And if it's, say, a recorded audio or video recording, you then play it or show it to the public. So it should be differentiated from communication to the public. And it's by electronic means. The one who communicate the piece of work and the recipients are not in the same place. And that's how we understand 28A. And 39.5A3. performance to the public, then you will understand the distinction, albeit a minute one. So it's in relation to where the recipients are vis-a-vis the one who released it. But it's the first time that I hear that the one who released the work is in the same place as the recipient. She thinks that that meaning is included. Say I'm here. I share something via my phone to Mr. Ray Chan. Then we are actually in the same place or not? And in 39(5)(a), you talk about a recorded audio or video clip, but we're not talking about that. There is already a clip in a cloud, stored in a cloud, and everyone can access it on a screen and view it on a screen. I think these standards are more and more muddled the more it is explained. I asked Mr. Wong to elaborate on in black and white, because I've never heard that if the recipient is at a different place than is under 28(a), that kind of communication to the public, because I've never heard it from the government. So please put it down in writing. Give us an information paper. And in relation to release, communicate, release, give me clear definitions. I know that they may not be covered under the interpretation section, but when it comes to different words that have different meanings, then I need documentary record so that we can trace it. So that there won't be different interpretation by different people. Mr. Ray Chan, perhaps I will ask Mr. Porter to ask questions first. He's in his first round. Members asked questions. I understand where they come from, because copyright ordinance is a technical piece of legislation. And when it comes to definitions, say publish, release, they are actually supported by cases, by authorities. When the world was simpler, well, there are specific ways to release or publish something. It's not like nowadays when you can do it on the internet. Yes, words like these will have to be redefined with care. Perhaps officials should use some easily understood cases to illustrate your point about the definitions, to show us what these words meant in the older days. Say dramatic work, artistic work. And now with the internet and with the amendment, then these words may have a different meaning. Well, I've dealt with these cases, and I understand why there are difficulties. And I'm not just targeting amendments proposed by solicitors or barristers. It's to help the public understand. Thank you. We'll give an information paper, and we'll use easily comprehensible words to tell you the difference. Well, use easy explanations and examples, please. users may not know the law very well. It would be better if you use easy to understand explanations. Mr. Ray Chan. For under section 39 is release and communicate. Well, we have had abundant discussion about communication. It covers almost everything, including playing through electronic means. Then I see another word. Issue is a verb in the Chinese version, but in the English version, it's not a verb. It's the issue of copies of the word. And there's also the word make available to the public. Does it have an even wider scope that it covers everything? Make available to the public. Why don't you use the make available to the public? Or is it the case that if there is a tangible item, then it's make available to the public? And if it's intangible, say streaming, then it's communicate. DS. Well, when it comes to making available to the public, we always use the word copies. And we introduced a new concept of communication to the public. Because sometimes if it's done on the internet, say streaming, then there is no copies. So we have to use a term that has a wider scope, that is along the line of the international convention. So if it's making available to the public, that should be a tangible item. This is an inadequacy. Why we have to do it this way. A better approach is to use the same concept as international conventions, because in our statute law, in the UK, do they use release and communicate? Well, a release is not used. I think it's make available or communicate. Making available to the public under section 26 is a specific right, which has a specific meaning, that is on the internet making available on demand. So it's an exclusive right. And in the copyright ordinance, there are lots of terms that have been defined. The right of making available to the public is mentioned in conventions, say the Berne Convention. In the UK legislation, there is no making available to the public, but communication to the public, which covers all. We have this specific right of making available to the public, so we have to use a different term. Then why don't you take back making available to the public? Making available to the public has been defined in the existing legislation, and in communication to the public, it covers that as well. And in various provision, making available to the public is kept. To avoid confusion, we use here release. The meaning of a release is to let the public know. That is, make known to the public by different means.
咁就同我哋之
Previously, we used the word broadcasting and make available to the public. They're different. But even for the word release, you don't need a real object. Well, a printed version will be included under the issue of copies of the work to the public. As for the word release, it will include real objects as well as electronic forms, and also on-site performance and playing or showing. Ms. Ito, I'd like to ask about 39 bracket 4. There we have A, B, C, and D. My first question is on B. The court has to consider the nature of the work. Well, when you use the words the nature of the work, what's in your mind? We mean the original work. It may be a novel or some information including data, facts, or movies that have not yet been aired, or books well known to the public. All those will have an impact on the nature of the work, so the court will have to consider a number of factors. And then when we look at the amount quoted, we may have to refer to the actual fact. Maybe sometimes the quoted portion is more considerable. Ms. Ito, is this understanding of mine correct? For works quoted by others for the purpose of criticism and analysis, that may be more difficult because you easily fall into the trap of infringement. So you want to avoid infringement as far as possible. Now, when you write in the nature of the work, I really don't understand the legislative intent. Previously, we analyzed the provisions on fair use. If you refer to precedents in the United States, if the degree of originality is higher, if the author has spent a lot more hard work on the work, then the more the work should be protected. That is the core of copyright protection. But sometimes a certain part of the work has to be cited or quoted. In many cases, where it doesn't mean that you cannot quote from any work. Data, information, etc. will have to be considered in terms of fair dealing. That is, you have to consider a number of relevant factors. We're not saying that you definitely cannot quote a work or a derivative work. Well, Mr. Chairman, we received a lot of papers from the administration at previous meetings. I wonder if that remark of Ms. Chong's is covered in any previous paper. CB4, 11, stroke, 14, 15, bracket 02. That's to explain fair dealing under the copyright ordinance. And then what about 4D, Mr. Chairman? The court has to consider the effect of the dealing on the potential market for or value of the work. So when you say potential market, what's in your mind? Well, by potential, you mean the market is not in existence yet. So do you mean the potential value or the potential market? So potential is describing what? What factors should be considered in determining whether or not a certain work has market value? Well, we have ample precedents in this regard. Internationally, we do have provisions in terms of intellectual property protection. Reasonable, conventional, or in ordinary circumstances, the copyright owner will authorize somebody to use his work. So we're talking about reasonable, foreseeable situations where the copyright owner will develop the market. And in the USA, there are some judgment or rulings related to the WTO that are relevant. Mr. Chairman, I'd like to follow up on Mr. Chan Chi-chun's question about bracket 1. Sufficient acknowledgement. Screen capturing very often is not criticism itself. It's just using certain dialogues in films for commenting on current events. Netizens have resorted to similar means to use episodes of famous movies to comment on current events. Say, in recent years, there's a popular film. If you quote from that film, of course, everybody knows what you're saying. But say, after many, many years, the film has become a classic film, then people may not know of the source when you quote it. If on the screen they have a subtitle, a small subtitle, to inform the reader the source, then that may become popular on the net. But in fact, the origin of that film may not be able to be traced by the ordinary public, but the copyright owner knows the origin. So, that's what by reasonably practical. In fact, netizens won't spend so much effort on digging out the origin. So what's meant by reasonably practicable? Ms. Chong, we use objective standards. Why do we need a sufficient acknowledgement and at the same time provide exemptions? That is, where and when possible, you should respect the author of the work and acknowledge the source. So, it should be an objective criterion accepted by the general public. If you can trace the origin of the work or the author of the work, you should acknowledge that. We'll say, as you said, after 10 odd years, the origin and the author cannot be traced, then the law will consider that you won't be able to trace the source because it is not reasonably practicable to do so. Mr. Chairman, why do we have huge reservation on this? Because if a dialogue is captured from a part of the movie, that act will not affect the potential market or value of the work. But we're worried that the person may not be able to obtain exemption because he cannot trace the origin. So that's why we're worried about criminalization of such communication acts. You only mention precedents. You cannot tell us specifically what you mean by if it is not reasonably practicable to do so. So very often you have to go to the court before you can defend yourself. We don't want to go to the court to defend ourselves. We want to write a piece of legislation such that people know their position and won't need to go to court. So the provisions should be clear enough to the service providers, such that they know clearly where the protection is. Protection for individual sharing is rather ambiguous. So please go back and see what can be done. Mr. Sin Chung Kai, I haven't compared the two drafts, but I'd like to ask something about 39. In 2012, when we tried to amend the Copyright Amendment Bill, eventually that amendment bill was shelved and did not get passed. I would like to know, in that version, did we have this Section 39? This is a new section. Well, the original ordinance already carries a provision on criticism, review, quotation, and reporting. Rather, it's criticism, review, and reporting back then. And now we've added two more means, quotation and commenting. That's why we redrafted the provisions. But by and large, we're just expanding the existing scope of Section 39. All right, colleagues, if no more questions on Section 39. Just now, some colleagues asked the administration to fine-tune certain provisions and expressions. And our legal advisor has something to add. Thank you, Chairman. Just now, Ms. Ho asked what papers are of reference to members. Well, let me say something by way of background. I did write to the administration to ask something, because for 39(2), the quotation is modeled on a UK Act. So I asked how this provision is different from the UK Copyright Act, and in what way are they different. The government has not sent us a reply yet. So if at the next meeting the administration is ready for an answer, it will be helpful to this discussion. And then for the proposed new Section 39(A), we also asked the government to compare it with the relevant provisions in the UK. So I would appreciate it that the government can come back with answers next time. Well, before the next meeting, can you give us the reply to questions about the new 39(A)? Well, we're preparing the paper. We'll go back and prepare all answers in writing. Mr. To, Mr. Chairman, this is not in order. I mean, in terms of the speed of submission of papers, we spent almost 2 hours on Section 39. But still, on 39(2), the government has not answered some of our questions yet. Yes, just now the officials tried their very best to answer our questions, but we want answers in black and white, such that whether or not this bill gets enacted, members of the public and netizens in future would have some references. If we don't yet have the answers, should we still continue? Well, the government has not answered some questions of our legal advisor yet. We'll, of course, pursue those answers. We'll handle new Section 39 capital A in the same way. In fact, the new Section 39 capital A is also a very important provision in this bill. We only have about 15 minutes left. I don't intend to continue. So before the next meeting, I hope the government can give us answers to our questions on 39 and 39A, and then members can go through them before we have our discussion. Our next meeting will be held on the 20th of January at 10:45 a.m. Mr. Chen Chi-chun, a final point on 39, fair dealing. We always compare ourselves with the UK, but I understand that in the UK they don't have any statutory law. They only have case law. But 4 points are given by the government here.
It may be a straitjacket for the court, because when it comes to case, then it may be changed. But if it is actually the statute, then the court's hands are bound. Please reconsider this. I thank Mr. Chen for asking this again. We've explained it before. We have supplied 2 sets of documents in relation to fair dealing, and it's explained in detail why the 4 factors are codified. In short, we think that clear guidance given to the court, asking it to consider all the circumstances, including the 4 factors, is itself a benefit, because there is still flexibility. The court's hands are not tied, and yet there is still guidance. And these factors are extracted from cases. Similar factors are considered by the court in other jurisdictions. And there are also fair dealing provisions in the existing legislation. Some users are concerned that it will restrict the court, but that is not the case. We're very confident that the court will use these provisions appropriately. So if these provisions are deleted, they will not have a significant impact on the operation, right? We honestly think that it is the best for Hong Kong. That's why we've drafted it this way. And back in 2007, there was another Bills Committee that has vetted our proposed factors, and members at that time think that it would be beneficial. This will be conducive to certainty of the law. Ms. Chen Yun-han. I will let Mr. Ma speak first. I don't have any comments to make. Mr. Ma? You said that you were not going to discuss anything else. In the last meeting, in the 28A456, there are still outstanding issues. We're waiting clarifications from the administration, and we're still waiting. I hope they will be given to us earlier. Hopefully they will be given to us before the 20th. There are no questions. Meeting adjourned. 20th of January, 10:45. Meeting adjourned.